Welcome to my webinar, Legal Webinar, the Golden Years Standard, Navigating Elderly Clients Through a Slow System. My name is Jonathan Burton. I'm a senior lawyer at Gluckstein Personal Injury Lawyers, where I've worked for 17 years. I'm 43 years old. I don't usually start presentations with my stated age, but in this presentation, I think that's important. According to a life expectancy chart, I have 42 point, oh no, I'm a male on the left, 38.8 years to go, hopefully more than that. And I've got 21 and change until age 65. If that's the way we looked at everything, these cases would be simple. But today's presentation hopes to highlight some practical considerations when representing clients in the golden years. We'll figure out what that means. And also different strategies in terms of knowing your own client and navigating our slow system, both in terms of our tort system, and then with respect to motor vehicle accidents, the accident benefits system as well. There'll be a couple of videos. Hopefully everyone can relax and enjoy the ride. So we've heard the term the golden years doctrine, but what exactly are the golden years? Because that could be different for different people. For instance, some people in the office that I'm working in now come into the office on a regular basis, and they're in their mid-80s. In terms of what the courts actually have to say about it, people have heard of the golden years doctrine. There's not a lot of chatter in decisions about it, especially in Ontario. Another OTLA member recently did a blog about this, and I checked his case law. That's Lawson Hennick. I looked through his case law. I looked through all the case law that I could find. There's very little in Ontario. Some of the cases, and by the way, this presentation, my slideshow will be available to anyone who emails me afterwards and would like a copy of it, so you don't have to take notes. There are 4 cases that come to mind: Giles, Wilson Estate, Nasinowitz, and Solanke. But it kind of starts with, and by the way, there's more BC decisions than Ontario decisions. It starts with Fata v. Heinonen in 2010 in BC. And this is an excerpt that I put into many mediation memos and pretrial memos when I'm discussing a client who's in their golden years. The retirement years are special years, for they are a time in a person's life when he realizes his own mortality. When someone who has always been physically active loses his physical function in these years, the enjoyment of retirement can be severely diminished, with less opportunity to replace these activities with other interests, etc. You can see at the bottom of this slide, not much case law in the golden years. Does that mean these cases are settling, or are there jury decisions that we don't know about? I don't jump to raise the issue of ageism when I'm dealing with elderly clients in these cases, but it's good to have this in your back pocket just to really know what it is. In this time we're in now, you don't often hear about it, but I do hear about it from my clients that are 65 and up when they feel like they're being treated differently strictly because of their age. Hopefully we don't have to accuse anyone on the other side of our cases of ageism, but let's make sure that nobody, including ourselves, are inadvertently committing the offense of ageism. To start off, I have a lot of clients that are older than me, and in the golden years category, either retirement age, post-retirement age, a little bit beyond 65 and up. 65 is the old retirement age standard. There still are laws in place that consider that the retirement age when you think about CPP, OAS in Ontario, in Canada. But I'm very proud to represent clients that are older than me. We can learn a lot from them. They have life experiences. They can tell us what it was like. I know what it was like before phones. They can tell us what it was like before color television and all the things we've taken for granted over the years. I'm going to play this video. It's something just to watch. I find it enjoyable, and it really sheds light on the older population. So I'm going to share this, see how this goes. The blessings of aging. Hopefully this works.
Do I feel my age? Not really.
I know I'm old in numbers, but otherwise I feel fine.
The thing that bothers me is that my kids are 60 years old. I'm staying young and they're getting old.
You look in the mirror and you say, oh my God, what happened to that woman?
We're old ladies, let's face it. So you're gonna come to my room one day and I'm gonna have a beard like Yasser Arafat.
I can't see well, I can't walk well, and I have trouble with my hands.
Otherwise, perfect.
Otherwise, I'm all right.
It's a blessing. Older you get, the wiser you become.
Are you getting smarter?
Day by day.
For me, the best part of getting older is losing inhibitions.
I don't care what anybody
I don't,
thinks.
I don't care either, to tell you the
It's
truth.
their problem, not mine.
You get away with stuff.
What you see is what you get.
That's it.
Take it or leave it.
That's it.
That's
Thank
the
you.
bottom line.
Don't bother me. I'll act silly
You don't like it, keep on walking.
That's all. Don't
Go through the
yeah,
door
right.
and don't come back.
and I'll get away with it.
Keep on moving.
Keep on going and going and going.
Time to move on.
Tell that person not to come here anymore. Being curious keeps your brain young. Have a passion, feed the passion. I'm still studying with the very great pianist, so we FaceTime.
I'm ready for you.
I wouldn't have been able to move here if I couldn't take my piano with me. It's the essential.
I mean, it's the way you look at things. Forget the age, just go on every day and take advantage of every day.
People that are in their 30s act older than I do.
I've learned to play flute.
Wonderful.
I think he thinks I'm crazy. Everybody who passes and sees me thinks I'm crazy.
Well, the only thing I have against her, she doesn't give me the money.
I am a die-hard Yankee fan. I love sports. Sports was my life.
You can still swim.
I'm coming swimming. I can show you a muscle. Not on the day,
Not now,
not now.
not now.
I play chess. I think I'm one of the better players in here. So that's one of the reasons I go downtown, you know, because they got the killers down there.
You meet women downtown?
Yeah,
You never told me that.
well, there's women all over, so.
I think all the people saw are very beautiful. And as long as I got a smile out of a woman, I was happy.
They allow overnight guests.
They do?
You didn't know that?
No.
Too bad.
Most of the men here are too old for me.
They wear their pants up to the neck.
Well, he can always lower it.
You know, the old men, they have their pants up. I'm telling you. She's hysterical.
Now my goal is to be happy.
You know, I don't have to take care of children, my husband, I've lost him. And someday I can decide, what do I enjoy? What have I really, truly enjoyed?
And I would like to dye my hair purple. I would think it would be a blast. It's a joyful color and it's a royal color. And I am royalty.
There's no need to think that your life ends at 65 or 70. Life is very interesting at 95.
Getting old is out. Getting older is better.
I think that getting old is pretty good. I really do. It sounds crazy.
But thank God for me, I have my full brains, I have my full head. Not of hair, but my full head.
Something to flourish. I'm looking for it, really. If I find somebody, I'm not gonna let her go.
Well, some people think when you're old, that's it, you know, but they're stupid. They don't know. Not too bad. Not too bad at all.
Okay. I'm back to the PowerPoint. I think that's an important video to watch because if our clients start off or before their accident have some of the attitudes that the people in that video have, You can see how good their lives are and that they shouldn't be written off in their case because they were already 80. They were already 85. They were already 75. So when a client comes in to your office or our office, sometimes we forget that the time that we spend with them in the early stages will save us a lot of time later. And especially in COVID times, where a lot of our initial meetings have been over the past few years, virtual, by Zoom, some telephone, fill in the blanks. It's really important to get on to things early in cases when you're representing 65 and up. And so I have a client technology checklist because I've learned that age is not necessarily related to the abilities of our clients to adapt to technology. I have lots of clients over 65 who are active on Facebook, sometimes too active on Facebook, and we'll talk about that. But go through the checklist so that you know what you're going to need to do with the client over the course of their case. Number one, are they familiar with Zoom? There's a very good chance that they've had medical appointments by Zoom in the last 3 years, or at least some online technology with their own family doctor, different specialists. So how familiar are they with that? Do they use their cell phone? Get all their phone numbers in your system, cell phone, landline. How are they with email? Can they text? Specific to Facebook, how active are they on Facebook? Either intentionally or inadvertently. Look into that. Log into their Facebook with them, or just go in and see what someone else would see just checking out their Facebook. Are they on Instagram? Many are. Twitter. How about signing documents electronically? Have they ever done that before? Is that something you can do with them when it comes to the point in the case where a document needs to be signed? And other. So go through that checklist. Obviously, each of those items will have important implications depending on the stage of the case. I think that the biggest one really for us now is our examinations for discovery, if you have to go to those in the case. Are those going to occur by Zoom? And if they are, try to find the best formula for success with that. With a proper preparation meeting, at least 3 days before the discovery, you can have a good sense of knowing if it's going to work out or not. It should never be the day of the discovery where the technology doesn't work, because even though it's not necessarily our fault or our client's fault, it frustrates everybody, including ourselves. So I've had a number of clients of all ages come into the office and do their discoveries from here. Everyone else is on Zoom, but they're sitting across the table from me. And there's some advantages in that too. It takes the stress of the communication of the technology working away from the client, and is back to the old days where it's just getting to the place on time, our office. And so I highly recommend that if you have any doubts about whether they'd be able to handle it. The other thing is with Zoom, I have a funny story about that. At least when they're in your office, also, we have more control over the environment. I had a client who was 93 years old at the date of, or 93 years young at the date of his discovery. And I told him many times that you have to be alone. So the setup was in his kitchen. His kitchen doesn't have doors that close, and his wife was in the other room. And he said, I know, she's not listening. She's not here. And I said to her, you really can't be within earshot. You can't listen. You can't say anything. It's better if you're not even. Anyway, so all I could see was my client, and the question was, what was the weather like that morning? And he said, I think it was sunny. And then in the background, I hear, it was raining. So, to avoid those sort of pitfalls, make sure it all works and maybe bring them into your office. Another important checklist to go through at the beginning of the file is knowing the clients and knowing the client's family. Why? Well, there's a couple things to keep in mind. First of all, depending on the severity of the case, you're going to want to know if there are potential Family Law Act claimants. So is there a spouse? Are there children? Are there grandchildren? Are there great-grandchildren? And when you look at a family doctor's chart and the first page has that lengthy history, and it often says mom lived till whatever, dad, Parkinson's, whatever. We can do that a little bit too, because this example, the same client that had the with the background in the living room, he was 92 when he was hit by a car in a parking lot, and that seems old. He's off the wheel. And when I was talking to him casually about his age, he said, I'm the baby in my family. I'm the youngest of three. My older sister lived till 99, and the other one's still alive at 99. All of a sudden, 92 is not so old. So think about that. Get that information. It's not a pleasant conversation to have, to talk about wills and powers of attorney. And certainly, I'm not going to draft those or help my client draft those. It's not my area of expertise. But ask, do they have one? Is there a power of attorney in case they can't make the decisions anymore? It'll save us a lot of time if we know that there are and who it is, and maybe even have a copy of it just for our file, in case our client loses capacity or our client passes away. Emergency contacts, get more than one. There's no harm. Ask, who do you speak to regularly? Get the children, grandchildren, if they're over 18. Sisters, brothers, get that information in the file so that if we, for some reason, can't contact our client, we can track them down. When doing this family background checklist, I like to think about the first 10 minutes of the examination for discovery that the defense counsel would ask, and make sure we already have the answers to those questions handy. Address, where did you live at the time of the accident? Where did you live before, if you had a different address in the couple years before the accident? Who did you live with? Names and dates of birth. So go through that family background checklist. The time you spend in the beginning can save a ton of time later on. And when we have clients 65 and up who have been injured in an accident, I really want to put in as much time as possible setting up the before. In a lot of our cases, when we're dealing with the issue of causation or other issues in the case and damages, we're thinking about before and after. And sometimes the before can be written off for someone who's in the golden years. And with that, I have another video to play. I'm going to put it on for one quick second because I think it's a nice little transition here. Screen share, video. Here we go. I hope it's working. Here we go.
I know, I hated those kids. In fact, I hate anyone that ever had a pony when they were growing up.
I had a pony.
Well, I didn't really mean a pony per se.
When I was a little girl in Poland, we all had ponies. My sister had pony, my cousin had pony. So what's wrong with that?
Nothing at all. I was just merely expressing.
Some coffee. Who's having coffee? He was a beautiful pony, and I loved him.
Well, I'm sure you did. Who wouldn't love a pony? Who wouldn't love a person that had a pony?
You said so.
When I was a girl in...
Who figures an immigrant's gonna have a pony?
Got to close that screen there and back to the presentation. So set up the before. So how do you do that? What are some of the before items needed? Photos within 3 years of the pre-accident. When your client tells you, yes, I was going to yoga classes, hot yoga classes. I was going to the community center doing this and that. Photos are invaluable in these cases. And what about videos of activities? I don't know about you, but when my kids see their grandparents, we do take a lot of videos with them, sitting and reading, sometimes doing physical things. Ask your client to connect you with their kids or family members who might have videos of them doing activities that they can really no longer do. Load up on those, get them. Those will go a long way. And I had a couple of those in previous cases that came to me by accident. I didn't even think about it at the initial intake until a couple of these cases. I had a client at her discovery with an interpreter. She was 82, and she mentioned the dancing she was doing at the community center. And she was really describing a high level of dancing that I couldn't really imagine because she's sitting beside me and she's quite injured after this accident with a couple surgeries. And I'm wondering how good was that? And then just casually in the hallway, I said, do we have any proof of the dancing? And the son said, yeah, a couple years ago, I took some videos of it. He sent them to me. They were just before the accident. She was incredible. And when I sent it to defense counsel, his response was, oh my God, because it was just so profound. So load up on those early on. They can go a long way. Another one that I had, which was really quite sad, a client who was a passenger in a very serious car accident, literally 45 minutes before the accident in Georgian Bay area, they had pulled over at a monument to take a picture, and she just looked so active and healthy. And that photo, which I highlighted throughout the case, had been taken 45 minutes before she was in an accident that would prevent her from ever being able to enjoy such an event like that again. So load up on those. Litigation timelines. So I think from the outset, we have to have a milestones plan. Number one is picking a stream. Obviously, in tort cases, there are 3 streams, essentially. There's small claims court, which is now claims up to 35,000. There's simplified procedure, which is essentially 35,001 to 200,000 in damages claimed, and everything else above 200,000 would be the regular stream. And I'll talk a little bit about simplified in a second. Issuing the statement of claim. We know that there's typically a 2-year limitation from the date of the incident or discoverability to issue a claim. But we know that once the claim gets issued, it's still a long process. So in cases involving persons in their golden years, why wait? Get that claim out early. Getting to examinations for discovery. You know, if the case has absolutely no prospects of an early settlement, hold firm, don't grant long waivers, don't agree to setting a discovery. Today, this presentation is June 2nd, 2023. If someone says, I have some dates for discovery in April 2024, some cases, sure. Golden years plaintiffs, no way, sooner, find somebody else. Mediation, is it a mandatory mediation? If it's in one of those regions, why don't you book mediation at the same time you book discoveries so that you don't have to start the mediation date selection process at discoveries, which can sometimes be over a year. So get that down. When do you set it down for trial? In trial. So sort of have a plan and a timeline. Simplified procedure, Rule 76, pros and cons. You give something to get something. And obviously, even though you can switch streams along the way, when you start in simplified, you need to get clear instructions from your client that the cap on their damages that you're claiming is $200,000. There'll be no jury. It's a 5-day trial. A pro or a con, depending on what happens at trial, is the cost, exposure, and risk for the losing side. 25,000 in disbursements is the most a plaintiff can claim. That can be a hurdle when you need experts. When you look at expert evidence and how it gets in by way of affidavit as opposed to viva voce evidence, it's tricky. You have to consider, is this the right case for it? Get clear instructions on that. But if you are going the simplified route and you do have those instructions, there are tools in the rules that can really require both sides to move things quickly. The timing of affidavit of documents in Rule 7603 is 10 days after the defense is filed. Who does that normally? Don't forget about Schedule D, where you have to put in the names and contact information of persons who have reasonable information involving the case. Rule 76.08 talks about the settlement discussion that has to happen at a certain point after the pleadings are closed. And 7609, the set down date, 180 days after the statement of defense. So those are very unusual compared to ordinary procedure and how long these cases are taking without simplified procedure. Changing gears, what if you sense a little bit of ageism, either intentional or inadvertent, from the other side? I wrote here, when we are 30, 70 seems really old. I used to think 70 was old, and now I have lots of friends in their 70s, and they're not old at all. So if the other side is sort of, shooing you and your case because your client's old, ask them to go to their website, find a lawyer with a lot of experience on their website, and say, why don't you run this case by your colleague so-and-so and let them know that you think my client's really old and sort of near the end of their life and working life or career. Remind this, oh yeah, there's a note there. Mention this to the pretrial judge. I had a pretrial where, you never know you never know what's going to happen at a pretrial, but part of the pretrial, part of the plaintiff's case was my client is in her mid-60s and was looking after her mother, who was 90. And part of the loss for the plaintiff was the inability to take care of her mom, who she chose to live with. And the defense counsel in that case said something kind of off the cuff. He wasn't trying to be rude or set anyone off. He said something about, well, at that stage, she probably would be in a home anyway, or something to that effect. And I was fortunate enough to have a pretrial judge who had lived with his elderly mother for quite a long time, and he did not like that little comment. And even though it wasn't central to the decision in the case or what was actually going on with the case, it was just sort of an inadvertent comment that set him off. And so for those people who have golden years, family members in their lives or in their golden years, you don't want to set them off, because these clients deserve just as much respect as any client of any age. So I thought that was noteworthy. Options if tort counsel is delaying. Let me just make sure I didn't skip a slide. Yeah, here we go. So take a look at Rule 50.01 and 50.13 of the Rules of Civil Procedure. I don't use them enough, to be honest, but I've seen it the other way, where my office was not so quick on answering the undertakings, and defense counsel wanted a case conference right away to set a timetable because we weren't doing what we needed to do to move the matter forward. And then I started thinking, maybe I should be doing that on mine where things aren't going so well. So what if in the example where defense counsel is suggesting a discovery 10 months from now or a year from now, when you're ready, your client's ready, and you don't want to wait? Take a look at 50.01 and particularly 50.13. 50.13 is a request for a case conference. Why do we have to wait till the Rule 48 five-year limitation or time period by which you have to set the matter down after the statement of claim is issued to get a litigation timetable? Let's get it early if it's not moving along. So I'm going to be thinking about that more. Obviously, in preparing for this talk, I had to look at different laws and see where things are. And it's helped me because I'm going to use some of these things more often if there's a delay. Why should we wait? We know that the court resources are worn thin and it's hard to get to trial, but at least pushing it along and getting on the list, we don't have to delay that unnecessarily. Yeah, and there's another part of the rule that talks about specifically setting a schedule of events in the proceeding. Lay witnesses are especially important. They're important in all cases. Written and signed statements, the videos I talked about earlier, get them ready. These are vital characters. These are people who know our clients, what they were like before. So we've got videos, photos, but what about the people who knew them best? Think about getting some of those will say statements early on in the case to really show that regardless of our client's age, they were active, healthy, and at least what were the things that they were doing that they can no longer do. Hope for the best, but plan for the worst. Timing of expert damages reports, FLA claimants. Those are decisions that we have to make on all our cases. This goes back to the initial intake and knowing the whole family. Make sure everybody's on the same page as to whether or not to include FLA claimants. If our golden years client is alive, we also have to factor in all the other variables when considering FLAs. If it's an MVA, there's a deductible. Regardless of whether it's an MVA, we want to expose an FLA claimant to a potential examination for discovery. So those are the usual things that we have to think about anyway. Capacity check-ins, it's a low bar. We're communicating with our clients. We're looking at their medical records. When in doubt, make sure we explore that there's capacity, because you don't want to be met with a situation where you represent a client, settle a case, and someone from the family afterwards tells you he didn't know what he was talking about. So, you can have those discussions, but really, if you're seriously in doubt, consider it. Ask for an assessment if the insurance on an AB doesn't already. Also, I like to send monthly follow-ups, set up monthly follow-ups. It doesn't mean I have to call the client every single month on the case, but always setting up a monthly follow-up in the file so that we don't lose track of time. For any clients, 3 or 4 months passing with nothing happening is not acceptable. And in golden years clients, we're trying to get things moving a little bit quicker. Recent example, be creative. So this is, I have permission from the bodily injury adjuster to tell the story, but I'm not going to use names. So here's an example. Let me walk you through it. For anyone who does this type of work, these are all the things we sort of, we look at when we're trying to decide what to do. MVA passenger, May 7th, 2022. Passenger in a back seat. Car runs off the road and hits a tree. Multiple fractures. Surgery in an acute care hospital for 3 to 4 weeks, and then in a rehabilitation hospital for another 2 to 3 months. She is 77 years old. She is retired. She is single, no children, lives on her own, but has friends. So I'm able to do some of the things I talked about in building the before from friends and other family members and siblings. What's the problem? What's the situation? She might be cat, she might not. We're looking into that. She's not instantly catastrophic. So the negative on that is her non-cat accident benefits limits are just about gone. Why? It's $65,000 over 5 years, whichever comes first. And unfortunately, because of the level of attendant care she's needed and used and treatment and devices, all that stuff is getting right to the line of $65,000. But meanwhile, the accident is only 1 year and 3 weeks ago. What can we possibly do? So in this particular case, the statement of claim was issued in December 2022. Why wait? That's June, July, August, September, October, November, December, 7 months. Some might even say do it earlier. Simplified procedure in this case, can't do it. Her level of attendant care that she's needed so far, the surgical intervention, the risk of future surgeries, it's just not a case that at this stage we could cap at $200,000 in damages. How can we get to the finish line? How can we help client in the short term? The AB money is gone. The CAP process could still take months or more. If she's assessed and found not catastrophically impaired by the insurer, to get to a decision in a hearing through the process, through the license appeal tribunal from start to finish is for sure at least a year, probably more. Can we consider a tort advance under section 258(5) of the Insurance Act? Probably not, but it can't hurt to ask. The tort advance is more linked to loss of income, which in this particular case, my client doesn't have. But could I make the argument that the fact that she has to spend all of her CPP and OAS money coming in on treatment is an indirect loss of income? Maybe. It can't hurt to ask. I didn't do that in this case, but what I did do is have a phone call with the bodily injury adjuster. So I issued the claim, and they're in a waiver period because the BI adjuster wants to talk about this file. On the one hand, it's not clearly going to be the full insurance limit, so nobody's writing my client a check for millions of dollars. On the other hand, it's premature because we don't know. And in this particular situation, which I'm now going to consider going forward in other cases, obviously it takes senior experienced counsel on the other side, or in this case, an experienced adjuster. The idea was floated about partially settling the tort claim. So for instance, we know that general damages for pain and suffering has its cap. It's $440,000. So it's somewhere between 0 and 440. It's not going to be near the top. It's not going to be near the bottom. Is there a way to resolve a component of the tort claim? Pros and cons of that. It can never be undone if her recovery takes off. Maybe she's getting a number that's better than she would later. If she declines and things get worse, you're stuck with that resolution. But it's something to consider when there's no flow of money coming in to take care of her, possibly for another year or two, and that general damages number can only change so much. So that was I was really intrigued by that suggestion by the other side, and there's other implications to it that everyone have to consider, but it's something that I'm considering on this particular case, and I thought it was a very creative solution from a smart bodily injury adjuster. Anyway, something to keep in mind when we're stuck, something other than There's other options too. There's litigation loans and things like that, which have their pros and cons. I'm not going to criticize those or endorse them, but if there's other avenues, definitely consider them. Golden years clients and accident benefits claims. So accident benefits claims for motor vehicle accidents. Just checking the time. Okay, we're all right. Those are tricky for a couple of reasons. Number one, when you're dealing with accident benefits claims, the question is, are they catastrophic or non-catastrophic? And if they're non-catastrophic, might they possibly be catastrophic? And then even worse than that is, have they been assigned to the minor injury guideline by the insurer? And in that situation, I sometimes have golden years clients who don't automatically qualify outside of the minor injury guideline, no fracture, no psychological impairment, but really take a look at the SAB section 18.2, the pre-existing. Even if you have serious soft tissue injuries and that golden years client has some medical conditions beforehand, like most of us do, if we're lucky to get into golden years, at least something, see if you can get support from the family doctor, because that's the doctor who's made those diagnoses in the past. And if you can get a strong letter from a family doctor endorsing that their patient's recovery cannot be achieved within the $3,500 of the minor injury guideline, that can go a long way. Sometimes you can get out of it just by arguing and sending the family doctor records, but hopefully we don't run into that too often. CAT versus CAT risk. Full and final AB settlements for golden years clients. How? Strategy. It has to make sense. Do you need court approval? So one of the things to take a look at is the living situation, and this could be whether your client is accepted catastrophic or not. Take a look at the living situation and look for the possibility of a home modification assessment. That assessment can yield results varying in range on what the recommendations are. In some situations, a settlement of an accident benefits claim is a two-way street. Both sides have to want to do it, and it has to make sense for both sides. And not only on the insurance side does it have to make sense to them versus continuing to pay out the claim until it either ends or the plaintiff or the insured passes away, but from the insured side, it has to make sense when you don't know how long the person's going to live and what are they getting per month. In some cases, if home modifications are reasonable and necessary and can be justified, and they do come out to a large amount of money, then even in clients who are in their 70s, 80s, and 90s, depending on the situation of the case, it might make more sense for the insurance company to consider a lump out in that situation. If they're going to have to pay $150,000, $200,000 towards home modifications, there are ways to consider a full and final. And sometimes they will include structures with reversions. It can't be a windfall necessarily for the applicant or the insured either. So look at combinations. What are the needs of the applicant, our client, in terms of attendant care, home mods? Is there a solution with an upfront amount of funds to the client that makes sense to them, with an ongoing benefit, or by way of a structure with a reversion period that protects the insurer if they want it for a period of time? Obviously, your client has to fully understand that, and the insurer has to be on board. But that is a way to consider an accident benefits resolution for a golden years client when the insurer doesn't seem to have much of an appetite. What can we do better as reps? Put ourselves in their shoes. Be patient. I've said it a couple times. The time you put in now will save time later. Connecting with elderly or golden years clients. I love to learn from them. We're the experts on our cases, and we're constantly giving them information and telling them what they need to do and what's going on with the case. It's really nice to sit back and listen and sort of take off the lawyer hat for a minute and put on a life hat. I wrote Norman and Olive at mediation. One of the best things that I still like to do during mediations have so much downtime where we're just sitting there with our clients. It's even more awkward on Zoom because they're just staring, anyone can look at any time. So if my bald head is down and I'm doing calculations for 30 minutes planning our next offer and they're just sitting there, it can be awkward. There's different ways around it with mute and stop video and breaks. But in a live mediation before COVID with Norman and Olive, during one of our downtimes, I just randomly asked them, I said, hey, who's your favorite musician from the 50s when they were growing up? And they told me, and then we put it on, we started playing it, and they got up and they were hugging and they were doing this little dance together. Good thing the defense didn't see how well they looked while they were dancing, but it was really nice. It was a special moment. I think about it, it's heartwarming. It really, if we don't have motivation already to represent our clients, it was really special. And you know what else it does? It also took off some of the edge of the whole process with them too. So really having a few tender moments with your own clients will help you. It will empower you to embrace their wisdom and represent them. I end the presentation. I don't have any more videos, but may we all live well into our golden years. So at the end of the day, every client is unique. Every client should be treated with respect. It's really important to get the information early when representing our golden years clients. Maybe some of us will make new law when insurance companies are not appreciating how significant certain losses for our golden years clients are, and are trying to minimize the situation based on their age. So that's the presentation. I will send anybody who wants a copy of it to them. Anyone who wants to ask me questions now on this webinar would be a good time, or you can reach out to me anytime, burton@gluckstein.com. Thank you for listening. Brenda, how are we doing?
We're doing great, Jonathan. I don't see any questions currently in the, you must have done such a bang up job. Oh, wait, I'm just seeing lots of comments about great presentation, great videos. So thank you so much, Jonathan. And yeah, if anybody has any questions, they can certainly feel free to reach out to Jonathan. This webinar will be recorded and posted on our YouTube channel.
Okay. Yes, I'm looking at a couple questions now myself. Do you have any go-to cases? I do. They're in the presentation, and I'll send the PowerPoint if you send me an email. There's about 4 of them, and then snippets from them. So, and I have those summarized in mediation materials. That's for one of the questions. I'm just going to look, see if there's anyone else. Yep. I think we're good. Okay, no open questions. Well, I hope everyone stays well and healthy.